Hey, what's up guys? Legal Bro here. Today we're back on Attorney React looking at a Florida stand your ground case and whether a ballerina killed her husband or whether the killing was justified and self-defense. Let's get into it. So one of the first places I think we need to look is Florida's statute on justifiable use of force. So essentially, when somebody is in a place where they are permitted, right, where they're within their home or their dwelling, that person has a right to use deadly force if they are in fear for their life or in fear of great bodily harm. And they have no duty to retreat. So unlike other states where, let's say, a robber breaks into your house, you've got to try to escape, right? You've got to go out another door. You can't engage with that person that's trying to hurt you unless you've tried to retreat or you had the or you've essentially run out of options and you can't retreat. In Florida, we don't have such laws. If somebody kicks in your door and tries to rob you, you can end it right then and there, right? You can absolutely defend yourself. Now, there are some cases that you learn about if you are a 1L in law school where people are, burglarizing houses and they've sort of set up a booby trap and that person gets maimed or killed. That's not what we're talking about here, folks. We're talking about somebody defending themselves in a place where they have a right to be and they use deadly force because they're in fear for their life. Now, with all of that being said, let's take a look at the ballerina's attorney and what he is trying to exclude as evidence or what the state may be trying to introduce as evidence.
The procedural requirements, as the court knows, Ms. Benefield sought judicial immunity pursuant to Florida's Stand Your Ground statute. She alleged, and we had the obligation to establish, that there was an objectively reasonable expectation that she would suffer great bodily injury or death, and that knowing what she knew about Douglas Benefield, the force used was reasonable. So to that end, as the court is aware, we established a prima facie case that the force used was justified. The state stipulated to that, and Your Honor signed an order so designating it. At that point, the burden shifts to the state to establish that the force used was not justified. That's what the statute says, and that's what the case law holds.
Okay, so this stand your ground case, they have stipulated two certain things, right? They've said that, yes, this is a stand your ground case, right? The state and the defense both agree and have stipulated to the court. But what the state has to prove is that the type of force used in this case was not justified, right? So if somebody punches you in the face and you're in fear for your life, you can punch them in the face back. But maybe taking out a gun and shooting that person would not be justified force. That's what we're getting at here in this motion.
The standard that state.
That's what we're getting at here when they're talking about this standard and the burden of proof for the state.
Has to meet to do that is clear and convincing evidence. So that leads us to what I think is a very appropriate consideration, Judge White, which is what are the parameters of a motion such as a stand your ground motion? I would suggest to the court that was pretty well defined in the second DCA case of Bowie versus State. I'll give the court the cite at 292 Southern 3rd, 471, and specifically page 483, second DCA case 2020. The court there pretty much stated that the inquiry for the court is to entertain any evidence which establishes that the force that was used was not justified. Which means, Judge White, that any other inquiries are irrelevant, specifically motive. Motive, a lot of times at a trial.
So what the defense lawyer is getting at here is that he's citing to case law, right? He's saying that this Bowie case says that the only thing we're supposed to look at is the force. We don't need to look at motive or any of these other things. Very interesting, but that's what he is trying to persuade the court to try to limit the scope of this trial, but that's how the defense lawyer is trying to limit the scope, whereas the state is trying to be able to introduce any evidence that they can.
Is not required. It's never an essential element, but when it is available, it's a very powerful tool for the state to present to a jury. Abuse allegations, also irrelevant, as is Ms. Benefield's psychological state. Why are they irrelevant? They're still, of course, subject to the rules of evidence, even if the court entertained them. But the question then is, why would they be irrelevant? And it's our position, Judge White, that they're irrelevant simply because they are not material to the stand your ground statute's requirements. As the court knows, the issue is, was Ms. Benefield in a place where she had a right to be? Was she involved in any criminal wrongdoing? And did she have an objectively reasonable fear of great bodily harm or death?
So there you go. The defense attorney lays out what the Florida statute requires and says, look, we don't need to get into motive. We don't need to get into the defendant's psychology, right? Their mindset, any of the things that they were thinking. We don't need to get into prior abuse. We only need to look at the stand your ground statute and keep that issue cabined and not let in all of this outside evidence.
So the case law supports exactly that. One of the benefits, Your Honor, of being in the Second Circuit is we have very well-defined case law on stand your ground. And I'll cite to the court two things in particular that should apply across the board to this hearing, respectfully. The first is in Riggins v. State, which is in our brief. It's at 344 Southern 3rd, 625, page 626. Also a second DCA case in 2022. Therein, the court held that the trial court, this is a quote, the trial court is to assume all facts as true. Secondly, I would cite to the court, also in our motion, the case of Jefferson v. State, 264. Southern 3rd, 1019. Again, a second DCA case, 2018. Here's what.
So you already watch enough crime shows, you already watch enough of these attorney reacts videos and enough court stuff to know that when an attorney is citing case law like this, and you learn about this pretty early on in law school, there are two types of cases that you cite to. You're either citing to a case that is binding on the court or something that is persuasive on the court. Now, because the case law cited by the defense attorney in Riggins and Jefferson's occurred in the same district that this case is occurring in, this would be binding precedent on the court. The court has to follow the decisions and opinions in those cases.
The Jefferson court had to say in upholding the stand your ground motion and immunity filed by the defense, quote, "We are mindful that there will be situations where the accused is the only available witness to the events leading to an act that is claimed to be justifiable use of force. This may result in great difficulty for the state to overcome the accused's prima facie claim by clear and convincing evidence. But our result here is mandated by the text of section 776.032, subsection 4, stand your ground." In closing, Judge White, I think that the state will be unable to demonstrate in any capacity, much less by clear and convincing evidence, that Ms. Benefield, knowing what she knew on the day of this incident about DB, which is the objective standard, Douglas Benefield, was not justified in using deadly force to prevent great bodily harm to herself or death. Thank you.
Thank you, sir.
Real quick, I just wanted to say that Attorney Tom / Attorney Reacts content is now on Spotify. We just launched a partnered show, link in the description. Go check it out. Now, back to the video.
So as most of you know, there are several standards in any case, right? The types of class actions that I do, the standard would be preponderance of the evidence. More likely than not, a peppercorn on the scale of justice would be enough to win your case or lose your case one way or the other. Now, obviously, you watch enough crime shows, you know that a criminal case is beyond a reasonable doubt, right? You think of the football field analogy, you are getting almost to that end zone, right? You're on the goal line. That's how far you got to take it. Clear and convincing is somewhere in between, right? So it's beyond preponderance and below beyond a reasonable doubt. I would probably think of it maybe like college football playoff, right? From like, that yard line. Maybe that's as far as you've got to take it. But in order to prove clear and convincing evidence, the state has to be able to put forth the evidence. And like the defense attorney says here that occurred in Jefferson, right? Remember, binding precedent. Sometimes the state's only evidence is the testimony of the defendant who has a stand your ground defense. Meaning, if the state can't call them as a witness, meaning the defendant doesn't testify, the state doesn't have any evidence. Because if you think about it, what are some of the common stand your ground type issues? It may be a domestic dispute with spouses, so maybe they're the only people home. It may not always be that third party that is attacking someone that they don't know. It could be a domestic dispute where the only people that were involved, where one has passed away and one has been charged. In that case, to the defense attorney's point, the state cannot meet their burden. They don't have any evidence.
All right, state.
State calls Tommy Benefield.
Judge, I suppose now we're into our omnibus motion in limiting.
All right, so it looks like the state is trying to call, it sounded like Tommy Benefield, which would be the deceased relative, it sounds like.
And you're talking about your omnibus motion?
Yes, sir.
Hold on one second.
An omnibus motion is going to be one that includes all of these things that the defense attorney is saying should be excluded. It's going to talk about all of these different areas. So it could be included in some of the areas of inquiry that the defense has already tried to keep out, right? Motive and abuse and some of those things. I believe that's what the court is getting at when they say omnibus motion.
I'm looking through. Do you want to go ahead and put whatever it is on the record related to Tommy Benefield?
Number 2, yeah.
Number 2. All right.
I had lodged an objection to any Benefield family member testifying without personal knowledge of or participation in the events immediately preceding the alleged homicide. I then followed that up with a discussion about testimony by non-expert witnesses who lacked personal knowledge and cited the Florida Evidence Code. And I also included in the memorandum for Your Honor the following. As the court knows, in a homicide case, the accused has the absolute right to open the door or keep it closed as it relates to character evidence. Only the accused can inject character evidence, after which the state is permitted to rebut it. It is the same thing with a witness's testimony under 90-404, Your Honor. Mr. Benefield is limited. The state can establish that Douglas Benefield had a reputation for peacefulness once it's attacked. The rule is very clear.
Okay, so do you understand what's going on here? When the defense attorney says open the door, he's saying that if the defendant in this case, right, decides to say how terribly abusive the deceased was to her, the state can rebut that evidence by bringing forth the deceased's relatives to tell the court how peaceful the deceased was. But if the defendant never opens that door, the state should not be allowed to bring in character evidence because it's immaterial to the issue at hand, which is, did they have any actual knowledge of the events that took place? It can't just be evidence of how great the deceased was. It had to be evidence, and it has to be actual personal knowledge of the events leading up to the events that unfolded in this case.
It has yet to be attacked. Mr. Benefield can only testify as it relates to the rehabilitation of character by the state for peacefulness to his reputation in the community. Mr. Benefield did not live here in this community. He can only testify to his personal perception of his cousin's reputation for peacefulness, which the Florida Evidence Code does not allow. That's our objection, Your Honor, respectfully.
Thank you very much. State.
And Judge, the state does not intend to elicit testimony about reputation.
Okay. This is a great example of what I was saying when we were talking about the hearing is I've heard your objection. I'm going to reserve on it because I don't know what these witnesses are going to say. I don't know quite where we're going. You guys know the case so much better than I do. So for now, I'm going to allow it, and I'll reserve at the end so keep making your objections. I'm going to reserve on those.
So the court's telling the defense attorney, look, we're going to let the witness come in and testify, but keep making your objections. And why? Because you need to preserve the record. If this becomes an issue on appeal, you need to have that objection preserved so that it's timely. And you can't just say at the end, yeah, we object to everything this witness said. It has to be timely. And that way the court can make a judgment call one way or the other. And I'm sure if at some point the testimony starts going into the reputational category that the defense seeks to keep out, the court may weigh the evidence and say, okay, at this point, this is not something that we want to include.
At least this one.
Understood.
Some of them might be a more clear call, but we'll pour it all in the pot and see what we get.
Understood, Your Honor, and I might say I'm quite comfortable with the court proceeding that way. I have no doubt.
Thank you. But let me say this. Having sat on at both tables, you make every single objection as we go that you feel you need to make. But I understand completely you have just a general objection to all of that character evidence, the background. You want to focus on that particular day.
Yes.
Got it.
Well, there you have it, folks. If you were the defendant in this case, I don't know about you, but I would feel extremely strong about my attorney. This defense lawyer is sharp. He really knows his stuff. And I think that the defendant is in great hands. It seems like the judge in this case is super reasonable as well, taking into consideration both sides and really just sort of feeling out, you hear him say, okay, we're just going to dump everything into the pot and see what happens, but really being cognizant of the fact that he's going to accept all of the defense attorney's objections, and he's really being mindful of the fact that this is a super important issue. He's not brushing aside some of those objections or some of the things that the defense attorney tries to keep out of the testimony. Overall, I think it's a completely fascinating case, and it's no wonder that it's caught so many headlines. If you like these videos and you want to see more, check out the other attorneys on the Attorneys React channel. You will not be disappointed. If you want to see more of Legal Bro Baby, come take a look at some of my videos. I'm a class action attorney. I represent veterans, service members, consumers, employees, and all of the little guys that like to take on big business, big corporations, and big insurance. We're always looking for a hero to fight back for the rights of the Davids versus Goliaths. Love y'all. Legal Bro out.
Big verdict.